format that I've wanted to experiment with for a long time. I'm picturing, the debates at Oxford where there's a lot of harumphing and guffawing and stomping of feet. And so feel free to indulge yourselves in that and not restrict yourselves to the high-tech version of voting with the clicker. The topic that we are going to be debating just could not be more central or in focus for the in this area. Google is an exceptional enterprise. In the last decade, Google has grown into a platform that is an integral part of the internet experience of over 1 billion people. With the reach of its search business and its expansion into adjacent markets, it has attracted the inevitable attention of the antitrust regulators. An EU investigation began last year. An FTC inquiry was made public in June of this year, and there were Senate hearings not just a few weeks ago, as many of you no doubt read about or saw. The Google matter has strong echoes of the Microsoft case of the late 1990s, something that we may hear about during the debate or in your questions. People are thinking of the question whether Google is the Microsoft of the late 1990s, and if so, what does that mean for what regulators should do with the case? And are the competitors like Microsoft and others who are complaining about Google, are they the Netscape or Sun Microsystems of the late 1990s? And if so, how should we treat their complaints about Google's conduct? So those are some of the issues that we're going to be exploring in the debate today. Now, to have a debate, you have to have a resolution. The resolution can't be neutrally stated. Can we go on to the next slide? Thanks. And by agreement, the resolution under debate today is Google has hurt competition. Now, this is not to suggest any bias, but it's just to have something to fight about. Let me say a word about the debate teams. First of all, thank you. This is a serious topic, and our debaters are serious people. There are business considerations that are involved in the Google question that have a lot of people's skin in the game. So I really appreciate their lending themselves to this and taking it seriously. Let me tell you a little bit about our panelists. For the proponents, Rick Rule, a partner at Cadwalader, the head of its antitrust practice. Rick has a storied career in antitrust, including serving as the youngest ever head of the antitrust division at the DOJ. And on behalf of Microsoft, he negotiated the settlement of the DOJ's long-running case against the company. Jonathan Kanter, his partner at Cadwalader, also involved in the Microsoft settlement with the DOJ, formerly at the FTC Bureau of Competition. As you all know, the bios are in your materials, so if you want to immerse yourselves in the glories of any of these people's careers, there are more details available there. For the opponents of the resolution, John Jacobson at Wilson Sonsini, a long and distinguished career in antitrust, including serving on the Antitrust Modernization Commission in 2002, a congressional appointment. He is currently an officer in the section of antitrust law. And Scott Sher, a partner at Wilson Sonsini as well, who focuses his career on the intersection of the IP and antitrust, just like this. Lots of litigation and merger experience in the area, and he's vice chair of the ABA Antitrust Section's Intellectual Property Committee. So one thing I need to emphasize is that none of these lawyers is representing a client here today. They are participating in a debate, so they are not here to speak on behalf of any particular client. The rules of the debate are as follows. Also, this is agreed upon. There will be a presentation of 10 minutes duration by the first proponent of the resolution. There will be a 10-minute presentation by the first opponent of the resolution, then a second presentation by the proponent, and a second presentation by the opponent, also 10 minutes in duration. We'll have a 20 to 25-minute period for questions, which, again, submit them via your iPads. I hope that's working. I'm very interested to know your questions. I hope there will be a lot of them to choose from. The only chance of your question being propounded is if you send it in. So if you do send in questions, and when you do send in questions, please indicate which side the question is to be addressed to. After the question period, then there will be a 5-minute summation by the proponent, a 5-minute summation by the opponent, and then we will we'll have a final poll. Now, one of the things that will be interesting is whether the resolution carries or not, but also we need to measure it against what people's attitudes are now. So we're going to take a pre-debate poll on the resolution. I'm not going to reveal the results to you, but we'll have it so that we can compare later. We're also going to collect some very basic demographic information from you to see if anything interesting shows up there, and after lunch we'll tell you whether anything did. So we need to register your clickers. If you would pick up the device that you will claim temporarily as your own, and look to the next slide, and please indicate what employment category you fall into by pressing the button on the keypad that corresponds. You only have 5 seconds to get this done. All right. Did everybody make it in under the wire? Now you have to give your age. There's a lot more responses to this question. It was easier to find the answer, I think. The third question is your gender. And a record number of responses. Thank you. So if we could move to the initial poll. The resolution is Google has hurt competition. So if you agree, vote A. If you disagree with the resolution, vote B. And if you're undecided, vote C. Terrific. There we, oh, even more responses. Terrific. During the debate, I will be the moderator. I'll be looking for questions, but I'll also be enforcing time limits. Again, this is by agreement. When a speaker has 2 minutes left, I'm going to hold up the sign. It is not a rating card. It's just a sign that they have 2 minutes left. And then when they're done, I'll be hitting the desk clerk bell, and that will be it. So your criteria for the vote is completely up to you. It can be the physical appeal of the debaters, or their use of rhetoric, or your preconceived notions. But I urge you to keep your minds and ears open and to enjoy the presentation. So with that, I'll turn it over to the first proponent.
Can everybody hear me okay? Great. Well, thank you, Chris. Last night we were having dinner, and someone came up and asked about the format for this debate, and my quick response was steel cage, and there will be first aid kits available. As I'm sure you know, and as I'm sure you'll realize, this is a highly emotional and a highly charged and a very serious issue that we're discussing today, and we want to thank Scott and John for for agreeing to sit down and engaging in what we hope will be a very constructive and at times even tastefully humorous exchange. So we look forward to that, and we look forward to your feedback. I think it's really critical, are my slides up here? Oh, the clicker. There we go. I think it's really critical to start with a little bit of context. So often you'll hear from folks, and you may even hear today, that the concerns expressed about Google and the regulatory investigations are a function of competitor concerns and a campaign really by one or two competitors just to smear Google. Now, that's fair for them to say, but I think what you'll find is you have a little bit of smoke, you have a lot of fire, and you have the fire department racing with hoses to try to put it out. We have 4 years of regulatory investigations. Google DoubleClick, the first time the Federal Trade Commission had the opportunity to look at Google carefully. The deal got approved after many months and millions of pages of review, but what the FTC said was, we're going to be watching this industry. Oh, and by the way, search is a relevant market and Google is dominant in that market. Almost shortly thereafter, the Department of Justice investigated Google's proposed transaction with Yahoo. That transaction was going to be blocked, not just on Section 1 grounds, but on Section 2 grounds as well. Google abandoned the transaction, but the DOJ issued a statement. That statement concluded that search advertising, once again, a relevant market. They also defined a market for something called search syndication, which is taking your search boxes and putting them out on third-party websites. It concluded that Google had over 70% in both of those relevant markets. Then you had the FTC investigating interlocking board directorates between Google and Apple. It asked Eric Schmidt, or forced Eric Schmidt, to step off the board of Apple. Then, almost immediately after that, the Department of Justice investigated Google book search settlement and eventually opposed that settlement, reaffirming in its papers to the Southern District that search advertising was a relevant market and that Google had a dominant position in that market. The settlement was ultimately rejected by the Southern District, Denny Chin, who's now in the Second Circuit, and in his opinion, he noted that Google and the department's allegation that Google had dominance in search. Shortly after that, Google had an investigation of AdMob, another opportunity by the Federal Trade Commission to look into Google's documents, and then Google ITA, which was challenged and ultimately approved with the settlement. The point of all this is now we have the European Commission, which opened an investigation after initial inquiry. We have the Federal Trade Commission, which has opened a broad-scale investigation into monopolization and anti-competitive conduct, as well as numerous state AGs. So you can ask yourself, okay, is this a couple of competitors who have a bone to pick? Or are these serious concerns? Are these agencies that have spent a lot of time looking at documents, talking to industry participants? I think there's 4 years of evidence and 4 years of history to suggest that, yes, these are agencies who have looked at, as you can see up here on the screen, these questions and have found that there's a lot of fire behind the smoke. So you have to start with, in any investigation, Section 2 is, what is the relevant market and does the company have market power? Again, numerous times the Department of Justice, and even affirmed by the Southern District of New York, has concluded that search is a relevant market. Google has over 70% of that market. There are estimates by some in the industry that Google has 80% or more of search advertising. Google has a dominant position also in search syndication. That market is defended, and that market power is entrenched by significant scale effects in Google, in search. Now, originally when I was preparing for this presentation, I thought, well, maybe it makes sense to have a bunch of moving, really interesting slides to dazzle you. And then I looked at it, and I decided that really Google's words tell the story better than any other slide or any other statements. So for the remainder of the slides, we're going to stick just to statements from Google and its representatives. And here you can see up some quotes from then CEO Eric Schmidt about the importance of scale, quotes from Google's chief economist, and then a couple of others from Eric Schmidt. The point here is that search engines learn by doing. They get better with the more people that use them. Therefore, search engines need search queries. However, search is free, something that I'm sure Google, John and Scott will remind you of. And they'll say, well, because it's free, you don't have to worry. It's really not true. I think an audience like this will appreciate, for example, the scores of radio cases where competition was not just one click away, it was actually one slight turn away, or broadcast TV cases where competition really was one click away and you can change your channel. But the fact of the matter is, these are two-sided markets, and what matters here is advertising. That's how Google makes over $30 billion a year, and advertisers want to be where the users are. So the more users you have, the more advertisers you have. The more advertisers you have, the more information, the more money you have flowing into your system. Search engines learn, the more queries that come in, the better capable they are to match results. Now this starts to level off after a certain period, but what you have here is you have a very powerful market defined by positive feedback effects and indirect network effects. Again, so now you go into the anti-competitive conduct. Well, what has Google done? Being big is not necessarily bad, and just because they have a monopoly in search doesn't mean that they've done anything illegal. And that's true, but we can see three categories of anti-competitive conduct. The first are exclusive dealing and exclusionary conduct. So we learned from the Microsoft case that exclusive dealing, one can be a Section 1 violation if it has the requisite foreclosure, but exclusive dealing can also be an element of a Section 2 violation and doesn't necessarily require the requisite foreclosure if it's being done to illegally maintain your monopoly. And that's what we've seen with Google. So back in the 2005 time period or so, when Bing entered and when Yahoo was trying to compete, they knew that they needed search queries in order to gain scale. So what did they do? A big source of search queries was syndication deals. You go out and you have a company like AOL powered by your search engine. You have a company like Ask.com, which doesn't power its own search engine to work with a Google, a Microsoft, or a Yahoo. Google went out and they locked up over 70%, some estimates 90% of the search syndication market. They locked these up through exclusive deals. Not just short-term exclusive deals, but long-term exclusive deals. The deal with AOL, which was absolutely critical in 2005, a time when competition was just entering the market with Microsoft and Yahoo was struggling to compete with its system, Google locked up the critical queries from AOL and many others in 5-year exclusive deals. Google's 10Ks went on to note that they actually spent more to get that exclusive deal than they expected to get in return. Phase 2, Google, through an interlock with Apple, becomes this default search for the iPhone, giving Google over 97% of searches from the iPhone. Now with Android, Google has almost 50% of the market. It's supposed to be an open source product, but actually it's not. Google uses compatibility certification requirements, as you see right here, to threaten and to require competitor or device manufacturers to use their search. The next are advertiser restrictions. So, you see these comments from Google that they never forbid advertisers from advertising on other platforms. Well, that's good. Google would never trap user data. That's a relief. We can all go home. Except if you look at their terms and conditions, it's not so much of a relief. What they do is they impede the ability of advertisers to take their data and move it back and forth between platforms. More than that, they impede the ability of software manufacturers to develop tools that would allow them to manage multiple campaigns on multiple search engines at once. And they impede the ability of these tools to allow advertisers to shift budget based on where they think they can get the best price. And this is really important because scale is critical. You need to get advertisers to your platform. It's much harder if you have to get them all to your platform at once. If you could plug into a tool that gives you access to all these advertisers, that would be far more efficient. And for at least 5 years, Google has had in place restrictions. These restrictions are not just on paper. They are not a paper tiger. They are enforced and regularly audited. The last category is the one that we'll talk about the least, but is probably talked about the most publicly, and that's manipulation of search results. So I'm sure we'll have opportunity after the closing bell to talk about that a little bit more.
Chris is working.
Switch to the other slides, please.
I'm certainly not talking to that.
You should feel free.
This is not counting against your time, Scott.
If you want, we can keep it up as a backdrop.
Exactly.
Yep.
Windows.
Share.
Thank you very much, Chris, Jonathan, and Rick. Today we're talking about whether or not competition is just a click away or whether or not Google's a dangerous monopoly. I thought for some history you should know that this is actually not the first time that Chris wanted to do this presentation. In 1996, actually, it was proposed the future of information, can any search engine ever compete with Alta Vista? Because Alta Vista at the time was the quote-unquote dominant search engine. Then in 1998, Chris wanted to do The King is Dead, Long Live the King. Will Yahoo ever be dethroned from its leadership in search? 2006, MySpace, the social network. MySpace at the time had a very high market share in the social network market. And I don't think many of you continue to use MySpace. Even though we've had this program proposed several times over the course of the last decade, the one thing I can tell you that has remained the same is that we've had to do the presentation on the same exact presentation software. So what is monopoly power here? And the question is, what is somebody's share, whether or not there is lock-in and high switching costs, and whether or not there are network effects in the market. Absent those three criteria, a company does not have market power in the relevant market. By the way, for everybody's context, I'm going to be addressing the issue of whether or not Google has market power, and I'm going to leave it to Jonathan to defend the practices that John Kanter mentioned. So generally, where you see a firm with market power in a technology market, the market experiences a decline in innovation or a slowing of price declines. First off, as a matter of law, Google does not have a sufficiently high market share to give it the presumption of monopoly power in the market. And for some statistics, ComScore and Hitwise, as of September 2011, said that Google's market share, coincidentally, is 64.8% in search in the United States. Second Circuit in PepsiCo versus Coca-Cola said, absent additional evidence such as an ability to control prices or exclude competition, a 64% market share is not sufficient to infer monopoly power. Go back to 1945, the Second Circuit said the same in Alcoa. It's not just the fact that Google's market share is insufficient to give it a presumption of market power, it's that people are not using Google as the gateway to the internet. In just over the course of the last year and a half, Facebook.com has overtaken all other sites as the website where people spend the most amount of time on the web. What does that mean? How is that relevant? Well, it means that Google's not the gatekeeper of the internet. People are not accessing news by necessarily going to Google. They go to the New York Times, they go to Facebook, they go to Twitter, and they're not getting there from Google. If you look at Twitter, only 11% of Twitter's traffic originates from Google. Only 10% of Facebook's traffic originates from Google. 20% of the New York Times. Fox 11%. Politico 12%. So at least from a news perspective, you can say, you know, Google is not certainly not a gatekeeper to other people getting onto the internet. And this begs the question of really, and we're not going to spend a lot of time on this, but what is the actual relevant product market that we're dealing with? I don't know about you, but when I go onto the internet and I'm searching for something. I'm searching for a product, I'm searching for a piece of news, I'm searching for restaurant reviews. And when you're doing that, you have a multitude of options. And when we say that Google has a 64% share of search, we're talking about general search, conceding as though that's a relevant product market. We don't agree with that proposition that general search is a product market. In fact, users don't either. 10 times the amount of product searches are done on Amazon and eBay than they're done on Google. It's hard to suggest that when you're searching for a product that Google somehow is a monopoly or has market power in searching for a product. The same is true in local. Yelp, as my partner John will talk about, has seen its traffic increase multiple folds since Google has become more active in the local search space. And if you are going to be just looking at a question of whether or not in the quote-unquote general search market does Google have market power, market share, you can see that Bing's market share has increased substantially over the course of the last 2 years, particularly after its agreement with Yahoo, and now sits at about 32% share of the general search market. Jonathan also suggested that Google has some reason has quote-unquote market power in the mobile market. I thought something that Peter Denkin said earlier is particularly relevant here. Google did not start providing Android before a year and a half ago. And to suggest that in a year and a half, because Google has gone from 0% to approximately 45%, that it has market power, when Apple's iPhone is in the market, RIM is in the market, Microsoft is in the market, is really not the way we look at whether or not a company has market power. And as evidence of that, I think if you look at what other people are predicting, that Microsoft will have by 2013 approximately 35% share of the market and may indeed be the leading mobile OS in the market. HTC announced last week that it's going to be shipping 30% of its inventory with the Windows platform. Jonathan mentioned that distribution is an important barrier to entry and expansion. If that's true, then Microsoft should have a much higher share in search than it actually does. 70% of the major PC OEMs are defaulted to using Bing as their default search engine. Not Google, Bing, 70%. Jonathan also mentioned that search syndication is an area where Google has a strong market position. Again, not true. There are three primary search syndication partners. Jonathan mentioned them as well. Yahoo, which accounts for 16.3% market share. Ask, which accounts for 3% market share. And the one that Jonathan focused on, AOL, has a 1.3% market share. Google competed against Microsoft for both the AOL and Ask accounts to become the default provider. Obviously, from here on out, Google will not have the opportunity to compete for the search syndication business for Yahoo, because Microsoft already has locked that up. Jonathan also suggested that mobile distribution has been locked up by Google, and somehow Android is not sufficiently open because there's not a sufficient number of users who could use Bing on the Android platform, and Google has locked up the iOS platform as well. A couple of important facts to note. Just last year, Apple put out for bid the ability to become the search provider for iOS, and Google won that, but it competed directly against Microsoft. And lest you believe it's difficult to switch, every single time you go onto the iPhone and use Bing, a message comes up and asks you whether or not you would like to change to Bing. So certainly, that's not locked up. Android is an open source platform, and on Android, you're allowed to, if you're an OEM of the Android platform, you're absolutely allowed to bid for to become the default search engine. Bing can become the default search engine on Android as well. The only platform where you cannot bid to become the default search engine is Microsoft. And I wonder when Microsoft has 35%, whether or not it'll allow its Windows OS, mobile OS platform to be put out for bid, or whether or not users and OEMs will be forced to use Bing. To briefly talk about switching costs, there are minimal switching costs, and although Jonathan and Rick are loath to hear that competition is just a click away, Just look at the relevant statistics. According to a Nielsen study in 2009, 72% of heavy internet users multi-home. They use multiple search engines. But they continue to come back to Google because they consider the experience to be better. They know how to, and they can go to alternative sources for search, but they continue to use Google. The same thing in 2009 from Forrester, from Performance in 2010, and from Microsoft in 2011. A natural experiment on the ease of switching. Google was infected with malware in 2009. Everything came up as saying that your computer would be infected if you went to a particular website. For that 1 hour that the error was in effect, Yahoo saw its market share double. If switching was hard, Yahoo should not see a market share double within an hour. So as a result, you have to say that search is a highly innovative industry. Look at what's happening. If this was a monopoly market, you would not see the sort of innovation that is occurring from Google alone and from all the other participants in the market. Contrast it to what happened when Microsoft had a 95% share in the browser market. We did not see a single release of a browser product from 2001 to 2006. Folks were saying that Microsoft had done damage to competition, innovation, and the pace on the web development, which was both glaring and ongoing. No one is saying that about Google because it's impossible to say that about Google because innovation can't be stopped on the internet. You constantly see new startups, you see Google continuing to innovate, and you see companies like Microsoft innovating as well. Thank you.
We're ready for our next presentation. All right, and if you can go back to where we left off. I think it was slide 8, maybe?
Slide 8.
Where's the clicker? Try one more. Oh, I should do that, right? Okay, let's see, that's not it. Oops, that is it. Okay, there we go. And how do I get to, there you go, thank you. All right, thank you. We all know what the question is. I want to make 4 points. First, I want to say that there's an old saying, famous to all us lawyers, if it looks like a duck, if it quacks like a duck, if it waddles like a duck, it might just be a duck. Question about ducks, though, just like with market power and monopoly conduct, you have to know the facts. And the difficulty here is, in terms of debating things, you're going to hear a lot, you've heard a lot of statistics on both sides. But ultimately, they are facts that are within Google's control that they haven't really allowed folks to hear. But let's talk about my points first. Google has monopoly power. Again, all you have to know is that, as Scott pointed out, you know, you could have talked about Alta Vista, you could have talked about Inktomi, you could have talked about Yahoo. Guess what? They don't exist anymore. There's really only one, there's Google's, and then there's one other competitor, Bing. And Bing is still in the market because of a bit of an anomaly that Microsoft is willing to spend over $2 billion a year in losses to keep it in the marketplace. The fact is that everybody else has been excluded. Google now tells you about a lot of facts about how many exclusives they have today, about what's happened to their syndication partners today. Go back to the time they entered into those exclusives. Go back and look at what those shares were before, in effect, they locked those queries in, denied them to everybody else, and then took them to themselves. But the biggest red herring of the presentation today, and in their arguments generally, is that Google's free. So why do we care about it? Well, we care about it because the company makes $30 billion a year. And I think for this group, you know, if you think back to the pre-cable days, and if ABC or NBC or CBS had decided to get all together, or one of them had basically bought all the programming and driven the other television networks out of business, except for maybe PBS, you know, they'd be up here making Scott's argument as well. The fact that it was given away for free obscures the fact that the reason it's given away for free is to collect eyeballs to sell them. And if you look at that side of the market, there, and Scott didn't talk about this, Google's share is well above 80% in the United States and well above 90% worldwide. They, in effect, dominate search advertising. And if you ask any advertiser, they'll tell you, I have to have Google. I can't go anywhere else. So the fact is that Google does have a monopoly by the standards that we usually look at. You can also say that they excluded competitors. They also raise price, because if you look at the revenue per search that they get, it's a substantial degree greater than what Microsoft gets. Second, Google's monopoly power has been sustained by exclusionary acts. Again, Jonathan talked about exclusive dealing. What Scott showed you is the situation today. He doesn't show you the situation in 2006, 2007, when Google went around entering into a lot of exclusive deals. I'm sure you're like me. You bought a computer at some point, you had Google on it and a Google toolbar, and boy, was it hard to get off. Or maybe you downloaded Adobe software, and somehow the Google toolbar appeared on your desktop and you couldn't get it off. Well, all that behavior essentially made it very difficult for anybody else to compete. Now they've basically switched that action to mobile platforms. And again, they've locked up Apple. They, in effect, notwithstanding those numbers, they're talking about 2013 projections. You know, I'm sure Microsoft would love to have that share, but that's not the current situation. Current situation is for mobile search, Google has 97%. That's a monopoly share. They also have been essentially acquiring content that's critical, oftentimes by allegedly taking it from others and not making it available generally on the same terms that they ask third parties to make it available to their search engine, giving themselves an advantage. Also, as Jonathan talked about, they've been locking in advertisers. And again, you know, they will say, and I'm sure John will tell you, that, well, we let advertisers do anything they want to with their data. But if you look at it, and it's true, Microsoft does say, here's the way you can do it. It's basically a 19-step process for moving your campaign from one engine to another. And every time you want to change your campaign, you got to do those 19 steps. It's kind of like somebody selling you a ton of cement and dumping it on your driveway and saying, now you can go sell this to anybody. But our restrictions are that you have to carry it by hand. If you want to try to use any third party that has wheels, you can't do that. We're not going to let you use any third party behavior, but you can take it by hand. Well, practically, that's not an option. And practically, that's locked in the case of Google, advertisers. And then finally, we talk about manipulation. Manipulation is essentially the exclusion of potential competitors who use structured data to focus on a certain area. The examples that Scott gave are not the ones that are dependent on Google for getting traffic, but there are a lot of folks like shopping comparison sites, NextTag, local search companies who have testified that, in effect, they depended on Google to get traffic. Google told them that they were going to get traffic. They wouldn't be biased against. And then they get biased once Google decides to go into those areas and capture the traffic itself. So again, I think the facts show that they've engaged in exclusionary acts. So that leads me to my third point. Now, Google has defenses for all this, and John will get up and tell you, we're just doing it to protect quality. We're just doing it for the good of the consumer. That's a good argument, I guess. But the fact is that that's one of the two alternative scenarios. Maybe that's what they're doing. Maybe they're doing this stuff to essentially deny scale to competitors, to essentially perpetuate their monopoly, and to exclude anybody who might take data or take advertising dollars away from them. We don't know. It's a fact question. There are a lot of people out there who say they have been driven from the market by Google. There are a lot of people who have been driven from the market by Google. There are a lot of people who are denied stuff by Google. So the question is, why has that happened? Well, the problem with Google is they're not going to tell you. You know, we have a couple of cases against Google. First time we talked to John, we asked John for a little bit of discovery, just a little bit. And John told us, if I give you any discovery, my client will fire me. He still works for them. They didn't fire him. He's done a very good job. And basically, if you look at the cases, he's going to come up here and cite all these cases that he says have been dismissed. Well, the two of them are mine. One, in the so-called trade comment case, it got dismissed on a venue question, not on the merits. They refused to even, they wanted to bifurcate venue from the merits. So, you can't cite trade comment for that fact, never touched the merits. Then there's another case in my triggers where they apparently messed up by filing a collection action in Ohio. We were hired to, in effect, file a counterclaim. They argued that the Ohio state antitrust law didn't apply. The court recently dismissed the case, but allowed us to replete, and they dismissed it on the grounds that we improperly pled antitrust injury, not on the merits. They don't have any cases that deal with the merits. They don't have any cases that courts have looked at the facts. So to me, just saying trust us doesn't work. And that kind of brings us to the credibility point. The point of these slides that Jonathan showed you, and I'll just show you a few more on vertical search sites, is that, and you should look at this later, I mean, look at the bottom one there, there's simply no truth to the fact that Google is preferring its own services. That's what John Jacobson says. But then Marissa Mayer, who's one of their leading officers, said when we rolled out Google Finance, we did put Google Link first. It seems only fair, right? We do all the work for the search page and all these other things, so we do it first. The fact is, they have a credibility issue. They have a credibility issue based on how they explain their case. They have a credibility issue because they won't show folks facts. I understand that. That's what lawyers do. They put up roadblocks in discovery. It's a well-trod path. But they can't, at the same time, prevent people from seeing the facts and then argue that the facts vindicate them. Fortunately, there are these investigations. I believe that after those investigations, we'll see Google's a duck. But I believe that the evidence that I can now show you, because that I have publicly, also supports that. And I should say, hopefully we'll get a chance after you finish, given these credibility issues, just to come up and make a few corrections if we hear some more of the inaccuracies that we've heard over time. But with that, I'll sit down.
Thank you. As John Jacobson makes his way to the podium and the presentation gets switched over, I want to remind you that we're about to have a question and answer period, which for there to be answers, there have to be questions. So if you have questions that are occurring to you, send them to me on my iPad. It is now working.
Good afternoon. Scott and I flipped a coin and he got the joke, so I'm unfortunately going to have to move in. So what is this all about? So every site wants to be first on Google. All right, every site wants to be first on Bing. Every site wants to be first on Yahoo. You can't do that. And the Google search, like Bing, like Yahoo, like AltaVista, is designed for the user, not for other sites. It's designed for the user. And that means that there are going to be some sites that show up higher and some sites that show up lower. And everything that Google has done, everything that Google is accused of doing by Microsoft and the other complainers is designed to make search better for users. And does that cause some dislocations? Of course it does. Competition makes life better for some, worse for others. So can it be an antitrust violation to try to improve quality by downgrading bad sites? And that's just completely wrong. And there are some sites that are so obviously bad that we should start with them just so that the point is clear. So JCPenney, I think you all read in the New York Times, gamed Google's rankings. They had a very sophisticated SEO who helped them figure out how to jigger their website so that it would show up higher in Google's ranking. So Google has developed quality mechanisms to prevent that. There's another one that was in the New York Times called Decor My Ads, which was a fraudulent eyeglass seller. So, and he was delighted with the fact that he had rigged his site, working again with an SEO to show up highly in Google's rankings. So Google has to be alert for bad sites. So does Bing, so does Yahoo, because otherwise the results are going to be bad for users, and users are going to go elsewhere. So let's talk about one of Mr. Rule's two cases. And he brought a case on behalf of a company called TradeComet. TradeComet was an arbitrage site. It was a site that lured you in, advertised on AdWords, lured you in. You would go to the TradeComet site, and what would you find? More Google ads. You would click on those ads, and TradeComet would make money. So the arbitrage is you pay for the ad on AdWords, but you get the revenue from the AdSense ads that Google provides to their site. And this is known as a type of spam. And here's a page from a website that we have nothing to do with, TechDirt, explaining why Mr. Rule's case was ridiculous and why this site was spam and why Google, in downgrading TradeComet, did exactly what users should want it to do. All right, so Foundum, another site, and we didn't talk about it today, another complainant, has tons of duplicate content. That is going to show up lower in Google's rankings. So every case, Mr. Rule mentioned a couple of them, he didn't mention all of them. Every case that has been filed against Google asserting an antitrust violation has been dismissed. Every case has been dismissed. Now, TradeComet was dismissed on venue grounds, but had it got to the merits, the reason that TradeComet filed in New York rather than the Northern District of California is there were two prior cases, Kinderstart and Pearson against Google, that made clear that if you applied the standard of those cases, which were, contrary to what Rick said, decided on the merits, that there was no claim, that downgrading bad sites is not an antitrust violation. And there are a number of cases that have held this, both on the natural search side and on the AdWords side. So, all right, so does Google favor its own universal results? The answer, and what I told Bloomberg, and what I'll tell you, is no. It does not favor its own sites, but what it does do is it tries to give Google users what they are looking for. So let's take a simple query on Google. This one is for sneakers. So Google shopping results show up as the fifth result on the page. There are ads on the top, there are ads on the right, but there are sites that show up higher and sites that show up lower. Let's take the same inquiry on Bing. What is the number one shopping result? It's Bing shopping. Absolutely, you can do this almost every time. Bing shopping shows up number one. Google tries to have an algorithm that does not pop up Google every time as the number one result. Same thing, a television query, 42-inch Samsung LED TV, Bing shopping number one on Bing. On Google, it's the number two result. Next tag, one of the complainants, is the number four result. So what if Google really did favor its own properties? Is that an antitrust violation? Every case addressing that kind of issue says no, absolutely not. The Trinco case, the Linkline case, Judge Posner's decision in the Western Union case involving soft drinks called Bayou Bottling, all of these cases say that favoring your own properties is not an antitrust violation. But people say, isn't that what Microsoft did? Isn't that why Microsoft was found guilty? Absolutely not. Microsoft was found guilty because it didn't favor Internet Explorer over Netscape. It did everything conceivably possible to kick Netscape off the operating system over which it had complete control. Google doesn't do that. Google doesn't enter into agreements with third-party disadvantage other sites. Couldn't if it wanted to, and it doesn't want to. But in aspects, and this is right in the Microsoft decision, when Microsoft did favor Internet Explorer, which it did by integrating into Windows, no other browser was integrated into Windows, by forcing it on users as the default, no other browser was forced on users as a default, and by overriding user efforts to change the result, Microsoft asserted quality justifications, and the DC Circuit in Bank said, fine, government, you lose on that, Microsoft, you win. Favoring your own results, which Google does not do, is simply not an antitrust problem. Now, get to the point that I made earlier that Google doesn't do this. Let's take product search, which is one of the things that Mr. Rule complains about. From 2007, when Google product search began through the first half of 2011, if Google identified a query as seeking a product, it would show a universal, a shopping result, only about 50% of the time. It had to be a query that Google interpreted as being for someone who was trying to shop and buy a product versus someone who was trying to find information about a product. Of that 50% of the time, Google's technology only allowed the universal to be in a fixed position, either first, third, or last on the page. That is not favoring Google's own products. Clicks on Google's shopping results are free, as are clicks on the Google Universal. All of these clicks are free. Google makes money only when you click on the ads, not when you click on these results. So was Google, hidden about these results? Remember, Google results at this point in time, up until April of 2011, could only appear for shopping results in this fixed portion of the page. Did Google hide that? No, it was completely transparent about this. Everyone knew about it. It was disclosed on blog after blog after blog. All right. So in April 2011, Google's technology improved so that universal results floated for shopping, and that is the way they do today. If Google had been trying to advantage itself over the major shopping competitors, would Amazon show up as high as it always does? No. Would eBay show up as high as it always does? Absolutely not. There's simply no teeth to the argument that Google was favoring properly or improperly its own results. And just a couple of slides that show that even today, next tag, one of the complainants, shows up well, which it does. I want to get to one of the arguments. I've got some stuff in here about Yelp, but I'm not going to have time to get there. So the AdWords API. So the AdWords API does not prevent users from porting their data from AdWords into Bing. In fact, Google has a tool, the AdWords editor, that facilitates exactly that. Google makes it easier for you to port your data from AdWords into Bing's Ad Center. And in fact, you would think that Microsoft, which complains here, but also portrays itself as a software company, might be able to develop software to make that process easier. And in fact, they have. It's not 19 steps. You can go onto YouTube or Bing's Ad Center and see just how easy it does. According to Microsoft, users can easily import your Google ad campaigns into Bing or Yahoo. So why is there any restriction at all? I know my time is almost up, so I'll try to be quick. It's simply this. If the third-party providers are able to commingle the Bing data with the Google AdWords data, then the person who sees the aggregated data is not going to be able to see how AdWords is doing versus Bing or how Bing is doing versus AdWords. The simple purpose of this provision is to make sure that the advertiser knows how successful its campaign is on AdWords and how successful its campaign is on other platforms. And my time has expired.
Thank you. To remind everyone, we're going to have a question and answer period now until 12:30, and then each side will have 5 minutes to sum up, and then we'll take another vote.
Chris, point of order. At some point, do we get to deal with some of the additional factual inaccuracies?
In the same way that presidential debaters insert answers to questions that weren't asked, I'm sure you can. I have a question for the proponents to start off with. And let me just tell you, though, that some of the Stanford's network, as a matter of hygiene, kicks people off of it after 4 hours. So you may find that your iPad isn't working anymore, and if so, raise your red flag, and one of the techs will come over and reset it for you. My question for Microsoft is this. Google has a tough time preserving the integrity and usefulness of its search results and has to move fast to keep ahead of various schemers who want to manipulate and undermine the search results, as we heard about from John Jacobson. How can antitrust courts possibly assess Google's moves and impose remedies in a way that doesn't deter beneficial innovation?
Let me start by saying, look, that's the nub of the question here. Quality, their argument is that it's quality, all driven by quality. Our point is that some of it may be due to quality, and there's no question that Google spends a lot of money trying to perfect its search engine. The fact is, Microsoft also, you notice in terms of innovation, Microsoft was very innovative, but that's not a defense to the antitrust laws if you're basically using your monopoly position to drive people out of the marketplace, to bias results intentionally to basically drive traffic away or deprive traffic to sites that you see as potential or actual competitors in terms of getting data or in terms of advertising sales. And I think the question that has to go back to the Google folks, because they're all over the lot on this, there are times when you can see, as we showed some of the statements, that John and other people at Google will say, absolutely not, we're completely neutral, everything is done by the machine, nobody ever goes in and changes those results. And then you can find probably an equal number of statements by them, typically their business guys, saying, yes, we do change things manually. Yes, we do, and there's a document that Foundum basically produced that basically indicated that they were told by Google that they had been whitelisted because they were a favored site, but then that later changed. So to me, the question is, if Google is deliberately going out and denying traffic to companies that are relying on it, like Nextag is claiming, like Yelp is claiming, like others, using its power to essentially exclude them from the marketplace, or in the case of Yelp, to steal their intellectual property, that's an issue. The only way to figure that out is to get their documents and to look at what they say internally. But if that's what they're doing, it's prohibited by the antitrust laws. And if that's what they're doing, there are remedies that you can deal with that. The most simple is basically a prohibition on using the algorithm to disfavor categories of competitors. It's very simple, and I can point to at least 5 decrees where there's language like that, and there are ways for the government to enforce it without interfering with innovation. The fact is, Microsoft, for the last 10 years, has been subject to that very kind of decree, and guess who the leading complainant on that has been? Who's been going into the department, who went into the so-called technical committee? It's been Google. And Google seems to think that it works pretty well because they use that mechanism a lot. No particular reason it can't be used with them.
All right, let's hear from Google, and I know you want to respond to that, and I'm going to ask a question that I think will give you the opportunity to address that, at least in part. Should there be any limit at all on Google's ability to change its search algorithms when those changes cause collateral harm to rivals? So, for example, assume an algorithm change leads to a very slight improvement in search results, but causes devastating harm to a rival. Should the algorithm change be subject to a rule of reason inquiry, or should it be per se legal?
So the law is the
You have to get very close to the microphone.
The law is the latter. The law is that a monopolist owes no duty whatsoever to rivals to refrain from discriminating against them. Now, are there cases that go the other way? The answer is no. Are there complaints going the other way? The answer is Mr. Rules. But the truth is that the law does not require that. But let's see the implications of that here. The implications are that everyone on the internet can style itself as a competitor of Google's, and everyone on the internet is indeed a site that attracts eyeballs in much the same way that Google tries to do so. So are we going to have a rule that says you can't discriminate against rivals when Decorme Eyes can set itself up as a rival? JCPenney can set itself up as a rival, where everyone can do so, and basically the decree would say, Google, you can't do anything in terms of improving the quality of your search, and that's simply not a rational result. That is the result that Fair Search, the Microsoft-supported organization that's behind a lot of this, is supporting, but that would be a recipe for disaster, but there would be a winner from that. And if there are constraints on Google's ability to improve its search result, to design its algorithm to get what users want, the big winner of that is Bing, because Bing will not be subject to those constraints. The inevitable result of that will be to slow down Google's ability to innovate and to actually degrade its quality. So the winner from that would be Bing. And I think that's one of the principal reasons that you see Microsoft behind all of these efforts. They're not behind NetStag, I don't think, but they're behind all the others to try to put Google in a very small box.
Let me,
Chris, look, you got to follow up in the sense that it's simply not true that the law says that a monopolist can discriminate freely against a competitor. Nobody thinks that. I mean, AT&T certainly doesn't think that. Microsoft doesn't think that. The problem with Google's arguments is they say these things that, I mean, if you're an antitrust lawyer, you've read the cases, you know it's not true. What I'm not sure about what was just said is Google admitting that it systematically discriminates against certain classes of websites, and is John saying that if they do that because they perceive those guys as threats to their revenue or threats to their data collection, that's perfectly lawful? Is that your position, John, that you do it and that it's perfectly lawful?
I didn't hear him say that, but John, you can speak for yourself.
Of course I didn't say that.
What's your position?
My position is that it would be an abuse of the antitrust laws for a court or a regulatory agency or some other body to try to dictate the quality of search results on Yahoo, on Bing, or on Google.
But just answer my question, please. Can Google discriminate against classes of websites because they're competitive threats? You said it's per se lawful. A, do they do it? And B, is it lawful?
I think the question about whether there's a difference of view about whether the cases say that or not. And so we're going to move on. But let me ask you this, and maybe this is a harder question to answer. This comes from the audience. A hypothetical to the opponents. If Google's downgrading or removal of a so-called bad site or a series of bad sites, showed a trend towards downgrading competitors to Google's non-search products, Flickr versus Picasa, for example, on a categorical basis, would you agree that that would be evidence of actionable abuse?
So the answer is A, that does not happen, period. B, no, that would not be actionable abuse if it did. All right, a monopolist is entitled to compete as effectively as it can. One of the very first cases I had was a soft drink case. It was cited in my outline called Buy Bottling. Buy Bottling in the Louisiana area, Coca-Cola had an 85% market share. Coca-Cola would go into stores with vending machines and coolers, and it would say, I'll put in a vending machine, I'll put in a cooler, but you're going to have to stock it exclusively with Coca-Cola products. And the Fifth Circuit Court of Appeals said that's absolutely fine. That's what the Link Line case stands for. It's what the Trinco case stands for.
is what Judge Posner's decision in the Western Union case stands for. But it's not what Google does. Google is subject to investigations, and the regulators are going to learn that every maneuver that Google makes, every change of its algorithm has one goal in mind, and that is to improve the quality of Google search for users. And there are a number of reasons for that. Google is not purely a profit-making institution. We can talk about that elsewhere. But it is extremely profit-maximizing to get the most users possible, to get people who love your site, to get people who want to go there, because that is what's going to attract the advertisers.
Just to respond to that, I think there's an assumption here that isn't right, which is that the interests of Google in maximizing its advertising profits is perfectly consistent with maximizing user quality. And if you look back at the founding of the company back in 1998, Sergey Brin and Larry Page wrote a paper, and in Appendix A to that paper, what they said is one of the big concerns they had was search bias and search manipulation. And what they said is that when a search company goes into the business of advertising, its incentives get changed. Its incentives are to maximize advertising, and no longer are its incentives to provide the best results to the user, but instead it's going to try to make the most money. It noted that this is particularly quote-unquote insidious because it's really difficult to detect even by experts, but even slight and subtle changes to algorithms can have a huge effect. Lastly, they concluded that it was competition and transparency that was necessary to keep this from happening. And I think if you look at, or if you're just looking at what John's saying, he's saying that we'll always have the user's best interest in mind, and that's enough to make sure that we're not acting in a way to maintain our advertising monopoly. And that's just not true. If you look at the situation with Yelp, what Google did is it actually took Yelp's content because it thought it was better, it put it on its own site, it advantaged its site, which had non-original content, something Google often complains about, and it demoted Yelp, which is the site that it originally took the content from. So it's just not consistent.
Let me ask, I have time for two more questions, and let me start with a question for the proponents. If Google wanted to make some vertical service, for example, YouTube, completely proprietary and off limits to unaffiliated search engines, what principle of antitrust law would prevent them from doing that? Does Google have a duty to deal with its rivals, and if so, under what theory?
Well, I think the argument is, look, if a company has a dominant position and they acquire an input that is critical to competitors, and assuming that you can prove both of those facts, then A, the acquisition is questionable, but B, their refusal to basically provide that input to others in a way that excludes folks from the marketplace can be an antitrust violation.
Are you saying that YouTube is an essential facility?
It's not that it's an essential facility, but it could be essential input. So, for example, and one of the things that Google touts and says that Bing can't catch up with are things like fresh results, the latest video on the internet. And if, in effect, all of those are in YouTube, and Google essentially provides access to YouTube that is different from what it advocates all third parties doing, because it claims that all third parties should provide that access to search engines because they'll get more traffic, then in effect Google is telling you that they are not providing access on terms that they think would maximize their short-term profits. They're excluding access or differentiating in terms of access in order for the impact in driving rivals out of the marketplace. The kind of analysis that the department has advocated for a number of years, advocated against Microsoft, and at least as I recall it, one of the things that John advocated when he was on the Antitrust Modernization Commission.
Question for Google, and then we're going to move to summations. If it can be shown that Google could manage its platform in a way that's just as beneficial to consumers but less harmful to rivals, should it have to do so under the antitrust laws? In other words, shouldn't you have to use the least harmful alternative means of a particular improvement to search?
No. Under the law, product improvements are almost always considered to be legal. You just have to look at the recent Ninth Circuit decision in Allied Orthopedic. If you can demonstrate that there's a benefit from what the company is doing, that is generally sufficient in order to sustain the product improvement. I think one thing that's important to point out with regard to that is you look at the actions of a company that clearly does not have any market power in the market and ask what they're doing. In the case of Bing, which does not have market power, we don't believe that Google has market power either in the search market. But if you look at what Bing does, is Bing clearly favors its own results. If you look at Bing shopping, it always comes up first. Why is Bing doing that? There's only one reason why Bing is doing that, because it believes it's in the best interest of its users and it's the best way to drive traffic. So the fact that Bing does it, there's no exclusionary impact of what Bing is doing by favoring its own content. It believes it's good for users. I think that serves as prima facie evidence that putting a result in that enhances the user experience, that shows direct feed to shopping results or direct feed to news results or direct feed to finance results is something that users want. Bing is demonstrating for us, Microsoft is demonstrating for us that actually, quote unquote, as Mr. Rule says, favoring content is exactly what users want, and Google is trying to provide what users want as well. That is a product improvement, and that is per se legal under the law.
Even if an equally effective product improvement would do less damage to rivals.
In that instance, there is possibly a slight room for that, but it's certainly not what is happening here.
I have just one quick one that came from the audience I'd like to ask the proponents. It seems like the exclusive arrangements that you are citing are from the 2005 to 2006 time period. Can you identify any exclusive arrangements that Google has entered into during the time that you contend it had monopoly power?
Go ahead. Yeah. Well, first of all, I think what you have to look at is the pattern. But yes, the exclusive with Apple, which is, as far as I know, still in place, where they're the exclusive default search engine for the Apple operating system and for the iPhone. But two, their de facto exclusive arrangements with their Android carriers and with their Android device manufacturers. We saw a quote up there that Google uses compatibility as a club. What it does is says, okay, it's open source, you can put whatever search engine you want. But if you change out the search engine from Google to somebody else, then you might not be compliant with our specifications. And if you're not compliant with our specifications, you may not get access to things like the Google Application Store. So that's compatibility as a club.
All right.
That's current.
One 20-second response, please.
So first of all, I think Jonathan is incorrect on the facts, and I think the best evidence of that is the recent Amazon Fire that was announced in the market. That was based solely on the Android platform. There is absolutely no arrangement between Google and Amazon that Amazon's required to carry anything from Google. It is making use of the open source software that Google has made available to all third parties. So I think it's absolutely false that Google has de facto arrangements with third parties in order to carry Google search.
And if you disagree with that, then you can mention that in your summation, which is about to begin. Each side will have 5 minutes, and then we'll proceed to a vote.
All right. Again, just to remind you of the 5 points. But ultimately, going back to the fact that, as Scott said, it depends on the facts. The facts are uniquely within Google. Hopefully, those facts will come to light as a result of investigations. But no one should be confused by the fact that Google is very opaque when it comes to revealing the facts of why it does things. And its typical argument is what John says. We didn't do it, but we could do it, and it would be perfectly lawful if we did do it. And so if there are people out there who are saying we did do it, I guess we did do it and it's lawful. The problem is, I think their recitation of the law is wrong. I think it ignores what's happened since Microsoft and beyond, principles that people like John, people who run Google, basically created. If those laws are going to apply to companies like Microsoft, companies like AT&T, they have to apply to companies like Google because, one, Google has monopoly power. And again, all you have to do is follow the money. And the money is search advertising. And if you look at their share there, where it's over 80%, and where, there's really the justification, that John had for, gee, the reason we don't let third parties create tools because you can compare AdWords results with Ad Center results. Gee, that doesn't sound very compelling to me. It sounds like they don't want to facilitate people using Ad Center, which is the competitor to AdWords. But at any rate, they have a monopoly there. They've basically excluded all the competitors. Two, there are a range of conduct that they have engaged in for a significant period of time, including exclusive dealing, including acquisition and exclusive control of content, trying to lock in advertisers, and essentially engaging, we believe, and a lot of other people do, in conduct where essentially they exclude others from the marketplace who are potential competitors. Now again, all those things are fact questions, and it's very difficult, that's why we have trials, that's why we have investigations, to actually know what the facts are. And it's particularly confounding when you have a company and its representatives saying basically, diametrically opposed points about what the facts are on every relevant point here. Who are you supposed to believe? Again, I think there has to be an investigation, and that's finally the fourth point, which is their credibility. And again, you have to look at the way in which they say things, the way in which they describe the case law. I don't think, and it's, Microsoft wasn't even bold enough to say that there was a rule of per se lawfulness that, in effect, they could discriminate against competitors. I don't think anybody has said that that is the law. And one should ask, if that's your argument, how credible is it? And with respect to credibility, I'll come back and hit a couple of points. One, on trade comment. Typically, in trade comment, and the reviews you see, occurred well after trade comment had been destroyed. And this is sort of routine practice at Google. These companies get destroyed, then they come back and they say, look how bad they are. Well, trade comment, interestingly, before Google decided to attack them, got an award by Google as being the website of the week. Their traffic was growing tremendously. Google says they're an arbitrage site. Well, guess what? They not only provided links, they actually provided some original content, some user-generated content. But it's always amused me when Google trashes other sites because they just provide links to other sites. They just provide advertising. Wow, that sounds like Google to me. But at any rate, so I think, again, you have to listen very carefully. You have to decide in terms of what the credibility is. What is your experience? When somebody says Google it, what are you doing? You know what you're doing with Google. If you know any advertisers, ask them what the must-buy is, what the most important kind of advertising is, and they'll tell you it's AdWords and Google. And that's the reason that Google makes $30 billion. They're not doing it because they're a charitable organization. And I don't think you can believe that. And I think if John is right, and he's advising them that you can do anything, it's per se lawful, and do whatever you want to, then how could the company not basically use its search engine and its market power in a way that maximizes its profits? And if maximizing its profits means destroying or excluding its competitors and depriving them of content, of queries, of data that allows them to compete at scale, they'll do it. They're like everybody else out there. That's what the antitrust laws are premised on. That's why the antitrust laws have to be applied to Google. And that's why I think you can believe the proposition that we're attempting to carry, which is Google has engaged in anti-competitive conduct, at least to the extent of requiring a thorough investigation around the world.
Thank you. Now the opponents.
So there's no question that Google is undergoing a thorough investigation around the world, so we'll see what the outcome is. I want to just make a couple of points. One, is it credible that Google would exclude trade comment and my triggers because they were competitive threats when Amazon and other sites that are really competitive sites show up so well in Google search? Is that credible? Or is it more credible that those sites were determined by revisions in the algorithm and new methodologies in terms of a quality score for AdWords that those sites were just deemed bad and insufficient for users, and that Google's testing demonstrated that those were sites that Google would do well for its users to avoid users, pointing users to. Just ask yourself that question, whether the claim even makes sense. Second, let's talk about exclusive dealing. Every deal that Bing and Microsoft is complaining about was contestable. There was competition for the contract, in Judge Easterbrook's phrase, for every one of those deals. Sometimes Google won, as with Apple. Sometimes Google lost, as with virtually all the PC OEMs, with Yahoo, with the assistance of the Justice Department, and with Conduit, the leading toolbar provider. There's competition for the contract on every one of these deals, and there are winners or losers, and these are not permanent arrangements. There is competition for the contract when those contracts are up. So is that an exclusionary practice? No. Is it competition on the merits? You bet. And finally, I just want to step way back and talk about the period when Bill Baxter became head of the antitrust division. And Baxter's view was that if a competitor came in with a complaint, you would listen very politely and then throw the competitor out of the office, because if the competitor was complaining, that meant that competition was working, because competition is bad for competitors but good for consumers. Now, I think, and by the way, I don't believe that, and I believe that there are numerous instances where a competitor has information and where the exclusion of a competitor can, in fact, raise prices to consumers. And I've written about that, and actually Mr. Rule has disagreed with that proposition on many occasions. But I agree that competitor complaints can be meaningful and significant, can be listened to. But what about the competitor complaints here? Does Microsoft benefit if Google search is better or worse? If Google search is degraded through regulation, through antitrust judgments against it, is that good or bad for Bing? Of course it's good for Bing. Does Bing have any interest in improving the quality of Google search? No. The worse Google search is, the better it is for Bing. So I think when you look at the initiators of these investigations, when you look at Fair Search, when you look at Microsoft, you have to wonder, is this an instance where the general rule applied by Bill Baxter is applicable? And I think when you do, you'll find that the answer is yes.
Thank you. Before I do anything else, I'd like to ask you for a round of applause for this marvelous advocacy. So, we are going to take a poll. It's the same question. The resolution is Google has hurt competition. If you agree, press A. If you disagree, press B. If you're undecided, press C. There are 8 seconds left. Discuss with your neighbors. All right, we're going to look at the results of the resolution first, the vote just taken. Remember, we took a pre-debate poll, and then we'll do a bar graph comparison to see how people's opinions have been modified by the debate. But let's look and see the fate of the resolution. Actually, go back one, please. 72% disagree with the resolution, so the resolution fails. Let's take a look at how the comparison between the pre-debate and post-debate. It looks like the number of people who agreed with the resolution declined The number who disagreed increased, and most of the undecideds obviously went into the disagree. Regardless of the outcome, I think it has been an enormously interesting and educational experience. Also a lot of fun to see everybody in action. As promised, we took some demographic data, so we'll try to identify during the lunch break what the ideal juror is for Google or its adversaries. And if there's anything interesting there, we'll come back to you with it. So the plan now is for us to adjourn for lunch. Lunch is in boxes outside. It looks like it's temporarily stopped raining, so you're welcome to mill around outside, find a place to eat. However, we'll be back in here at 1:30 promptly to begin the Carl Shapiro and Mark Lemley program, so please be on time or even a little early for that because we want to make sure we have enough time for it. Thanks very much.